Although all Americans are familiar with the Second Amendment's protection of the right to keep and bear arms, it is often surprising to learn that the Supreme Court said very little about this issue until 2008. Faced with a high rate of gun violence, the District of Columbia passed an ordinance banning handguns within the city limits. The city of Chicago did the same. In a pair of decisions in 2008 and 2010, the conservative majority on the Supreme Court struck down both of those bans, applying the Second Amendment to both the federal government and state governments. The Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The District of Columbia and Chicago argued that the amendment's phrasing means that individuals only have the right to bear arms within the context of a state-regulated militia, and that gun regulations are a permissible method of dealing with gun violence. The court rejected both arguments, holding that the right to bear arms is an individual right with no connection to a militia needed. However, both the District of Columbia and Chicago had completely banned handguns, which is a pretty extreme solution. The court noted this, and it emphasized that the right to own a gun wasn't absolute. Justice Scalia suggested that some gun regulations might be permissible, writing that nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. So the question became which regulations, if any, the court would uphold. To the disappointment of gun control advocates, the court has struck down most of the attempts to regulate guns that it has considered since 2008. One of the most significant of these cases was New York State Rifle and Pistol Association versus Bruin in 2022. For decades, states required individuals to own permits before they can carry concealed weapons in public. But the Supreme Court declared all of those laws unconstitutional in Bruin, representing a dramatic new restriction on states' ability to combat gun violence. In another case that didn't directly involve the Second Amendment, the court limited the ability of the federal government to limit bump stocks that convert semi-automatic weapons into automatic ones. The court's conservative majority has dramatically expanded gun rights in a very short time, but it has upheld restrictions on gun ownership in 2 instances. In 2024, the court decided 8-1 that it is constitutional to prohibit someone who is the subject of a restraining order for violent behavior from possessing a firearm. In 2025, the court upheld a prohibition on ghost guns. Guns must have a serial number when they are sold. Ghost guns are a way to try to avoid this law. Ghost guns are shipped to a new owner not fully assembled and without a serial number in order to make them untraceable. However, it only takes a few minutes to complete the assembly and create a fully working, untraceable gun. The court upheld a ban on ghost guns by a 7-2 vote. While the court is very supportive of gun rights, it will uphold restrictions in extreme cases.